Okay, 2 minutes will be starting the session. Good evening, everyone. I heartily welcome for the today's session. I'm Pavitra Hegde. I will be your host for this session. Let us experience the joy of learning. Remember, a new learning is always difficult initially, but becomes a habit eventually. Kindly mute yourself. Request ask questions at the end of the session. Today's agenda is welcome and introduction, journey so far, Disciples India Group and Disciples India Learning Forum, guest speakers introduction and the session. Disciples India Group vision is to excel as a focused and fulfilling learning destination for new age growth aspirations. Our mission is we will be a practice-based professional training and platform through novel and relevant process of transformation to individuals and organizations. This is our quality policy and core values. Disciples India Learning Forum. Disciples India Group Bangalore is happy to present a platform purely for the joy of learning. It is envisaged to be an exciting learning platform where like-minded individuals and organizations can come together, share experiences, and learn and grow as individuals, professionals, and organizations. Disciples India Learning Forum objectives: to provide a platform to share and exchange ideas and experiences, to create and develop personal and professional network of learners, to enhance effective communication and leadership skills, to foster learning and contribute for personal, professional, and organizational development, to update with life management skills, and contribute as an effective member to the society. Disciples India Learning Forum Organizing Committee Members 2022. Dr. A.M. Suresh, Advisor. Dr. Sandhya N., President. Mr. Muthukumar, Vice President. Mr. Patros Mathai, Secretary. Dr. Satish M., Joint Secretary. Mr. Shivprasad K.M., Treasurer. Mr. Akhilesh N., Executive Member. Disciples India Learning Forum completed 86 learning sessions from last 4 years to till date. Today's session, Associate Partner, Hoysala Degree College, Nelmangla. Hoysala College, situated in Nelmangla, is a prestigious institution established by the great visionaries of Sri Sai Educational Trust in 2016. Hoysala Degree College has been educating young minds to learn and to cope with challenge of the modern world and to design their future with value-based education. Disciples India Learning Forum in association with Hoysala Degree College. Present learning session is 87. Topic is Will and Gift. Its legal implication for Indian citizens. Today guest is Mr. M. Jagadish. Now I am request Miss Deepthi of Hoysala Degree College, Nelmangla, introduce the guest speaker. Please, Deepthi, introduce our guest. Deepthi?
Jagdish sir has graduated law from Bangalore University. Good evening, everyone. I am Deepthi from Hoysala Degree College. Now, I would like to introduce our Honorable Chief Guest, M. Jagdish Sir. Jagdish graduated law from Bangalore University in 1999. Thereafter, he joined the corporate law firm Marcos and Companies, Bangalore in the year 1999, where he was involved with the corporate practice of the firm, serving the legal requirements of clients' companies in varied areas of practice. Thereafter, he joined Murali and Company, Bangalore in the year 2007 and was heading the litigation team and practiced before the various courts and tribunals in India. Thereafter, he joined as a senior associate with Anup S. Shah Law Firm, Bangalore in the year 2011, where he was involved in drafting conveyance, due diligence, and real estate laws for the top builders and individual clients in and around Bangalore. Jagdish is currently managing the Bangalore office of Tapas Law since 2015, involved in commercial, civil laws, and real estate practice. Few achievements of Mr. Jagdish were simplified Kundalini Yoga and Transcendental Meditation, Landmark Education Curriculum for Living, DTM, Distinguished Toastmaster from Toastmaster International, that is Communication and Leadership Organization USA, past president of First Indian Toastmaster Club in India known as Garden City Toastmaster Club number 9015, past area governor of E3 District 82 and founder president of Resonance Toastmaster Club, certified mediator from Bangalore International Mediation, Arbitration and Conciliation Center, panel of ADR, ODR, International Accredited Civil Commercial Mediator and NCLT Hyderabad, life member of National Institute of Personal Management, Indian Society for Training and Development, Bangalore chapter, POSH trainer, honorary secretary in Lahari Advocates Firm, visiting faculty in few reputed colleges and also a keynote speaker. He can speak English, Hindi, Kannada, Tamil, Telugu and a little bit of Malayalam. It's my honor to introduce and welcome our Chief Honorable Guest, Mr. Jagdish Sir, to this session. I welcome you, sir.
Thank you, Ms. Deepthi. Sir, you can start the session now.
Okay. Can I have the sharing, can I share the screen?
Yes, sir, you can.
Is it visible?
Yes, sir, it's visible.
Very good evening to everyone. I request everyone to be, okay, now let's see the agenda. What is the agenda for today is why the session, will and a gift and a question and answer. Rules for this program is like this. It's going to be interactive. Do not wait for question and answer session. As and when you want to have a question, please raise your hand in this. Sir, I can take your question so that we will then and there give the answer or doubts, whatever you have, so that we'll clear it off. Then another challenge, another request is one at a time will speak, not more than one. And 3 is I love to see if you can keep the video on so that it becomes very interactive. I always believe that tell me, I can forget. Teach me, I may remember. But if we involve ourselves, we will learn a lot. That's what Benjamin Franklin says. Okay. Now we will see. Now, still, I don't see many people on the video. If it is possible, please come on video so that it will be very nice. Okay. Here we go. Will. What do you mean by will? Will is a document which is written by a testator to the legatee. What is all this testator, legatee, and all these things? In a simple form, if A wants to give a property to B, A is a testator and B is a legatee who gets it. Now, you may ask salient features of valid will. The name of the testator is very, very important in any will. If A wants to give a will to someone else, for sure, we have to bring the exact knowledge or the particulars of the particular person. Why? Because if A, you want to define him, then A is going to give it to B. A, what is his name? Son of, aged about, where does he reside? Then you say, so that it becomes very, very clear tomorrow on the absence of A. All of you know that Bill will come into the picture only on the demise of A. So in the lifetime of A, it will not come into picture. It will come only in the picture only when A is no more in this world. At that time, it becomes very, very clear and easy to have full particulars of the testator. Then, right to appoint a delegatee. So the testator should have a right to appoint a legatee. Why? If a testator is of unsound mind, he cannot definitely appoint a legatee. Or if he is, am I clear? Some disturbance? All right. So if a testator does not have the powers to give a will when he is of not of sound mind, or sometimes he is sound mind, but often he goes off, in the sense that he might forget something when he's doing something. So at that time, it becomes very, very important that we put a clause in the will saying that now the testator has got all the knowledge and he knows what he is doing. Sometimes we also recommend in few cases when people are going through, as we all know, in the oldies, we get into a lot of challenges. So there are some diseases which they might forget it now and then, not forever. For example, maybe 1 hour, they'll not know what's happening. After that, they might know what's happening. So during that 1 hour, when he's not knowing what is happening, if he executes a will that be valid? No, it will not be valid. So it becomes very important that we put a clause saying that when he was executing the will, he had a sound mind and sound body, and he was aware what he is doing. And sometimes it so happens that there is one case which I handled wherein a person was visually impaired after some time in his lifetime, but he writes the will during when he was visually impaired. So is that valid or not? So there what we have done is that he had a certificate from the doctor saying that he was with the doctor and he read the entire thing, the person who wrote it, and he understood as and when he put a thumb impression. So there are many, many things may happen. We'll have to be very, very careful when we draft a will. Then, as we all know, that the will come into picture only after the death of the testator, not during the time. Why? Because as a person, as a A, today I want to give a property to X. I wrote a will. But as we go along, as we all know, change is very, very constant. That is the only thing which is permanent. Tomorrow, I don't want to give to X, I want to give to Y. So I have all the right to make a change. Thereafter, after I give to X first, then I give to Y. Now I want to give to Z. Can I do so? Yes. There is no bar. I can keep changing n number of times as long as I'm alive and as long as I have a property. So definitely I cannot give anything when I don't have a property. I should have the property, number one. And number two, as long as I am alive, I can keep changing it. Even before a minute or 1 hour, I can keep changing it. So that is the beauty of will. Next, revocability under the law. As we all know that I can keep revoking any number of times as I am there. Today, I wrote a will. I got it registered also. Again, as we'll be going through it, will is not compulsorily registrable. It's only option. However, it is advisable to register the will. for a simple reason that we might not have too many challenges after the testator's demise if you're not registering. Now coming back, what happens if I register a will? Can I keep amending it, or can I still keep making one more will? Yes, for sure. You can keep making any number of wills. That's called codicil. We'll keep changing the laws from time to time as per the particular person, A's wish. Intention of the testator is supreme. So in a will, the intention is very, very important. Sometimes he may not be able to write the will on his own. So he may ask somebody else, executant. He may ask a support to prepare a will. So in that case, executant should be very, very vigilant and careful to understand what does testator wants, what is his intention. So he, for example, most of the time what happens is, who are the executor? It happens to be a good friend or a well-wisher of testator, wherein testator has a lot of faith on him, is called an executor. So he will execute on his demise. So executor has to really understand what the testator wants. Only on that basis he prepares it. Similarly, as an advocate, also if you are involved to prepare the will, you have to really understand, spend a lot of time. There is no hurry in preparing the will unless until you have that clear intention from the testator. Do not prepare or ink it. What we call in law is that we may prepare many, many wills, but the minute you put an ink, that becomes will for that particular time till he revokes that one and creates another one. So when you create a will, you be very, very vigilant on the intention of the testator. Then the declaration to be the last will. Anytime a will is written, we always say that is the last will at that particular time. Why? If you see, we always put the date in the will. So for example, if A is executed a will in the year 2021, maybe January, now today he wants to write one more will.
ಅದಕ್ಕೆ ನೀರಜ್ ಏನಂತ ನೋಡು ನಮ್ ಅವ್ರ ಜೊತೆ ಎಲ್ಲ ಚೆನ್ನಾಗಿರ್ತಾನೆ ನೋಡು ಅವ್ರ ಬಗ್ಗೆ ಎಲ್ಲ ಹೆಂಗ್ ಹೇಳ್ತಾನೆ.
Sweta, can you mute please?
ಅದೇ ನಮ್ ಬಗ್ಗೆ ಹೇಳ್ತಾನೇನೋ.
Hello.
Ma'am, kindly mute yourself.
Thank you very much. Right. So we put the date. It's very, very important, because like this, if you, when you say last will with the date, then we see which is the last will. Which is the last will, so that we give effect only to the last will, not the previous will. Then last subsequent will. So if I say a will is last, then we also see what is the previous to that. That will not have any value. Kinds of will. There are two kinds of wills. One is privileged will, another one is unprivileged will. Privileged will, as the name says, is prepared by a people who are in defense, who cannot come for sub-register office and register it. So they have privilege, so that when a person gives a will, if I am an army person or a defense person, so I have a privilege to create wills. Unprivileged wills is a person other than the people who are not privileged. Like a citizen, anybody else other than the people who are involved, not in the defense area, they're called as privileged, unprivileged wills. It talks about this one, and Indian Succession Act 2025, also called privileged will, unprivileged wills. Now, who can make a will? A person who's major, who's got a sound mind, can prepare a will. And also, a person should have a property. It could be movable or immovable. Both can be transferred or written in the will. Next is for whom the will can be made. As I said earlier, the will can be made only by a person who's a major. However, to whom it could be made even for a person who is not a major. It could be a kid also. Sometimes it could be kid who are going to expect it tomorrow. Maybe I will say, this property will go to my grandson. Today, with the due respect, my son I have, but he's too young. He's not even married. But today I'm writing a will saying that my property will go to my grandson, who will be born to my elder son. So I give very, very clear picture saying that elder son's kids will have a property of mine, who is not there in the world today. Now we will see general procedure to make a will. Any will should have a declaration in the beginning. Now, what is declaration? You declare that first and foremost, you tell like a story, who you are to start with. So I am A, born on so-and-so date. And as you go on, you picked up a property on your own, or did you acquired property on your own or from your ancestor? You have to say that. Why I'm saying this is you can give only your self-acquired property, ancestral property, unless until you get your share for yours very, very clear. Only that can be given as a will in the will. But you cannot, for example, if I have a property of my father's, which is yet to be partitioned, I cannot write a will on the entire property. Why? Because I do not have all the rights. My sister, my brother, my siblings will have a share in the property. So it becomes very, very clear that when you want to write a will, that property should be self-acquired so that you know what you can do. You have all the right to do with that. And also further, for example, you also got married. You would say that, yes, I got married to so-and-so, so-and-so, on so-and-so, so-and-so date, and I was happily married. Then I have been blessed with 1 or 2 kids. You say that. Then you say that due to my love and affection, I want to give this property to so-and-so. I want to give this property to so-and-so. You distinguish everything. And also, you also need to distinguish whether it's movable or immovable. Again, movables are, for example, like you might have a wonderful jewelry of yours, maybe a pendant, a keychain, or a nice furniture, or a nice picture which is worth a lot. So you can give, all those will come under movables, which can be moved. So you can make a schedule of movables, schedule of immovables. Further, here, one more thing. For example, if I have a bank account, can this be given to my legatee? Yes, you can give even you have to exactly bring out what is the passport number, which bank account, which branch, what is that money, how much you have. Sometimes what happens, I might have a fixed deposit of 5 varieties. So I can tell the first 3 will go to my elder son, the other 2 will go to my younger son or a daughter, whatever it is. So you have all the rights and privileges to make it very, very clear and specific so that tomorrow the executor does not have too many problems to divide or to transfer the properties. And as we see, details of ownership of the testator. So you should say, how did you own this property? As I was saying earlier, was it self-acquired? If yes, you mentioned that it was self-acquired by me, or if you got it from as a gift from somebody else, say that so that it becomes very, very clear for tomorrow. There is no problem when we transfer the property to another person. Attestation of the will. This is very, very important. Why? What is attestation? We all know that will now, we know that we got an entire history of a person. How did he devolve? How did he got this property? How did he arrive at it? And what he wants to do and to whom he wants to do it. And also, we also saw the details of the property and the documents and the ownership. Now, if everything is said, then the testator puts a signature or a thumb impression, as the case may be. When I do that, it has to be attested by definitely minimum of 2 witnesses. Sometimes we might see more than 2 witnesses. It's okay, but it has to be more than 2. Why? Because sometimes some people may say that this particular will is not executed with his own will or own conduct. He was coerced, was forced to write like this. So there could be contention after the testator's demise. So these 2 people, witnesses, will come as a rescue for you, saying that no, there was no force because I was present at the time of he executing the will. But let me tell you, the witnesses may not know the contents to an extent. Sometimes they might know, but not necessarily they should know the content of it. As a gesture of goodwill, you might say, if you are the executant, look, see, I have so many properties. This property I want to give to so-and-so. This property I want to give to so-and-so. You may say out of your own will or your own wish. Having said that, law does not prescribe. It all says is that witness should see that the testator is the one who signed on that paper, which is called as a will. So he tells only that, yes, I saw that the testator signed before me only. With the due respect, sometimes what happens, as I said, there'll be 2 witnesses. One witness is present next to the testator. The executant reads out and the testator signs it. One witness puts a signature. Another witness, they start thinking who will be the next witnesses. Sometimes it happens in practicality. So you might ask, what happens if the other second witness signed much later? Yes, what will happen is he will be the person who knows that, yes, this signature is A's only. He should be knowing about it. Without that, he cannot sign. For example, if A signs today along with another witness, witness also signed today. They could not find that second witness. Now, few days passed. After that, they find a witness. Then they request, can you be the witness? So he says, yes, I'll be the witness for you. So he or she signs the will as a second witness. Now you might ask, the testator signed maybe 3 days earlier. Now he signed it, whether it's right or wrong. If the witness knows that, yes, it is A is the one who signed it earlier, whom most of the time it always, we go with the known faces. Yeah, it is A only who signed it. That's perfectly all right. Okay. Then all this challenges only when you don't register it. To register it, what happens is A comes to sub-registrar office. He puts a signature. There are 2 witnesses. They fold it and register it. then we don't have all this problem if you register it. That's why we advise it is always good to register the will so that tomorrow you do not get into too many challenges because of this one thing which is missing, that's called unregistered. Having said that, sometimes it so happens that you do not have a time and energy to go all the way to the sub-registrar office because the person who writes is little aged or he cannot move. There are a few challenges. We do have way out for that. So there are ways. For example, if a person cannot come to a sub-registrar office, you can always file an application stating that he is not well, he is immobilized. There's a doctor certificate which confirms that he cannot mobilize. Kindly send your person to the residence so that we can register wherever he or she is staying. Sometimes it so happened in one of the cases, I took the sub-registrar's person to all the way to a hospital where the patient was there who want to execute a will. So there are many, many things which we do in practical things. Now, as we know, we saw the registration of wills. So section 18 talks about wills. 18 talks about a document which is optional. So that's where our will comes into the picture. It is not mandatory. Having said that not mandatory, it is optional. If it is possible, kindly make sure you register a will. Now, revocation of wills. As we saw earlier, revocation can be done by a person on my own, voluntarily, saying that, yes, yesterday I did it, today I do not want to do that. I want to cancel it. So I cancel it and write one more will, or I cancel entirety also. That's also possible. Not that definitely when I say last will, which means that I should keep having wills after will. No. For example, I have a property in, say, Bangalore. I have one property. I wrote a will. Now, for some emergency, I need to sell the property. I can sell it off. So what I do, I revoke the will and I sell the property. And I make some money out of it. I can either deposit it and make another will for that particular person, or I may buy another bigger property or a smaller property, give it to him or her. That's my entire choice. So no one can question me. Oh, look, that day you wrote a will to me. How can you revoke? No, no questions asked, because most of the time, they don't even know that there is a will which I gave it to him. It is very, very confidential. I write a will. I'll tell only to the executant whom I have faith. Otherwise, I'll not even say that. It's not like other documents where we know the contents of the will. Then next is involuntary revocation. What do you mean by this? Voluntary, I know that I do on my own. Involuntary is, as the word says, without mind, it could get revoked. How? Anybody? Okay. So what happens is, earlier, what happens is, if at all you have, which is not applicable for Hindus, for Indian Succession Act. For example, if I write a will, I get married, then what happens is my rights to that property is not the same, because of Indian Succession Act says that even a person who comes into your life, even he, she, or gets the portion of the rights. So that's where they say that in such cases, involuntary revocation may be applicable. Then we'll have to see what are the acts which is applicable for wills. These are the 4 acts which is applicable for will. One is Indian Succession Act 1925, which is applicable to all the Indians, in particular for the Christians. And then Hindu law, for sure, as we all know, Indian Succession Act, we have Hindu Succession Act also. Hindu law says also applies here. Muslim law, again, there they have little bit distinctions there, which we will cover it as and when we go along. The next is Indian Registration Act, which talks about Registration Act, which we already talked about it. Section 18 says that it's an option you have whether to register the will or not. Now we saw about will so far. Anyway, it's always good to interact, but since I know I do not know why we are not able to interact. So I just want to have question and answer only on the will portion. Then we go to the gift little later after taking the questions. If it is okay with the organizer.
Can I have a question?
Please, sir.
Yeah. So my name is Muthu Kumar. The question is that, for example, my sister is married to my Jiju,
Yeah.
and for some reason, mother-in-law passed, and she has got a property, and she wants to gift it to the daughter-in-law or the son.
Okay.
But son has two other sisters. Matlab, she has 3 children, 2 daughters and one son.
Okay.
But her interest is to give it to only the son.
Okay.
But unfortunately, now sisters will also file a case against it in future because she's not written anything as a will, but she's expressed it a couple of times. Now, husband is a half property owner. Matlab, it is registered in both the names.
Got that.
Yeah, father and mother's name. Now,
Yes.
what's the case now? But father likes the daughters more.
Mhm.
So, how is this?
Correct. No, Muthu, thank you so much for your question. This is where the will comes into picture. We have many things on our mind, but are we going to say the same thing, or is it going to be the same thing applicable? So that is where will comes into picture. If I don't write a will, it goes as per the law. You have no choice in it. The minute I write a will, it is my choice. I can choose a person whom it has to go. Coming to your question now, only his share, I told you earlier also, whatever you are owner of the property, only you can share it off, not somebody else's. So similarly,
for example, I and my sister are the partners of this one. It is not defined who's got what shares. We both bought it together. We are the owners, but it is not defined what portion of it. In
Got
some
it.
scenarios,
first and foremost, you have to have a clarity who's got a property. Then only you take the next step. It's all step by step. Unless and you're not clear with who's the owner of it, you can't write a will.
yeah, both husband and wife are the owners.
Correct. Then
So-
husband and wife should write a will.
Okay, both jointly should write.
Exactly.
But she is no more. How will she write a will now?
So what happens once she is no more? The rights goes to whom? The legal heirs.
Okay.
Okay. So she made a mistake by not writing a will.
Correct.
Now her share cannot be given to any one person. It goes to all the legal heirs.
Okay.
Okay.
And is there any fixed portion that the daughter should get so much, son should get so much, anything fixed?
Today it's equal. We had earlier a lot of challenges wherein we said that only men will get and all those things, and daughters were several things. The father should be alive, father should be born on so and so, daughter should be born on so and so. There are a lot of things were there earlier, but now today by God's grace or whatever, with a lot of developments in the law, today men and women are equal. There's no distinction between a daughter and a son. They get equal share.
Okay. So in such scenario, a husband can write, still he can write a will, right? One person
For
can
his
write a
share. For his share.
will. Okay.
Not for his wife's share.
Okay.
So, well, let me tell you practically what will happen is if the wife died, what would have happened in a immovable property, Kata will be transferred to the husband's name 90% of the time. Then he gets a right entirety 100%. Then he can write on his own. Okay, again we have to go in depth of the case.
Hmm. Right, got it. Okay, sorry, I took a lot of time.
Not at all, not at all.
One last thing.
Please.
If in case he writes a will now, all his property, let's say this portion of important property goes to his son only. He writes a will and he is no more in future. Who will, can the sisters come and file a case? No, I want a share in that property.
What happens is, good. This is where, that's why I was allowed to ask questions. So when after a will, what happens is we have to go get a probate from the court. What is probate? Probate is a certificate issued by the court along with the will. So what happens in your case, A goes and files the case in the court saying that, look, my father wrote a will in my favor, kindly give me a probate. So when you do so, what the court asks is, who are the other people? Is there anybody there? Your kids, your sisters. And what also happens is, this court gives an order after paper publication. So they also give a paper publication saying that if any person who's interested in this property, please come before me. So in that case, the sisters will come. Then the court will ask, okay, why do you require share? Then they'll say, look, your lord, I am also his daughter. And this will is done without our intentions, or it is done with some ill intention. If at all they prove, only then they get order in their favor. If they are failed to prove, son still gets it.
So they can still go to the court and put it on stay for a long time.
Exactly.
Right, got it. Sure. Thank you.
Any other question on the will? Just since Muthu had asked this question, so where do you have to file a probate? It's a question, right? Because, for example, India is a vast country. And today I'll be in Karnataka, tomorrow I'll be in Maharashtra. There I might be in Uttar Pradesh for a work, because it is today the whole, it's become like a global village. That's what we call it as. So we don't really stay in one place for a longer time. Given the scenario, where do I file a case? What happens? It'd be nice to have few snippets. So what the law says is, where the property is or where the testator died, you can either file in any two places. For example, today, let's say the property is in Bangalore and the testator was staying with his son, maybe who was working in Mumbai. And while he was staying in with his son or daughter, due to some maybe sudden thing, he is no more, he passes away. So the son or a daughter has got a choice either to file a case in Mumbai or the property which is in Bangalore. So they can choose any one court to ask for the probate. Okay. Any other questions? Otherwise we'll go to gift. But I think Muthu also got a little bit gift also in the question. But again, it was very clear thereafter he stood for will, which we are right now dealing with. Now let's go to the transfer. What is transfer? As the picture donné says, we give a property to another person. Okay, that is gift. Section 122 of Transfer Property Act defines a gift as a transfer of movable or immovable property. Now, it could be both, like what we saw in the will. So before I go into the gift, I always say two things to clients who come to me and approach me. If possible, why don't you give a gift? If you are very, very clear why I say so. In Mr. Muthu's question, we saw that there could be a lot of ifs and buts. But whereas if I give a gift, we put a full stop. With a due respect, when a will, it's only a comma because it does not come to conclusion. whereas gift is a conclusion. Why? During my lifetime, I know for sure it is my daughter or a son who's enjoying my property. Okay, they don't need to go to court once again after my demise to benefit or enjoy the benefit of the property. Sometimes what happens is the parents think that, oh, no, if I give a gift, the son or daughter may not take care of me. I agree. A lot of people, a lot of clients come and tell me this. But having said that, there are ways where we can take care of this small misunderstandings which you might have it. So what we do there is, we always say you give a conditional gift. What is conditional gift? We give a gift to son or daughter, whomever they want to give it. But we put a condition saying that till their last breath, they have to take care of him or her, number one, or they have to give the rentals to them till the last breath. So by this putting conditions, you still see that yes, your son or daughter is enjoying the property without any hassle of litigation. And they may also be happy to take care of you, and they have more respect, because what happens, as I said, they will not be knowing till executant comes and says, look, here is a will, your father wrote it, this is for you. Whereas in the gift, you also go along with your father or mother and take the property, and the ownership comes into you. You enjoy more in this than the will. Okay, next is parties to the gift. There are two parties. One is donor, another one is donee. Donor is a person who donates. That's called donor. So I give it to somebody else. That is donee. Again here, donor has to be definitely a major. He cannot be a minor. And he should be of a sound mind. And for sure, he should be the owner of the property on which he is donating to somebody else. He cannot donate someone else's property to someone else, because there will be a challenge tomorrow. Until you have a clear ownership, you do not transfer that to the donee. Now again, coming to donee. Donee can be a person who is a minor, who could be of not sound mind also, not a problem. As long as donor is sound mind, donee can be anybody else. Now, few things on gift. As I said earlier, gift can be done with a condition, and gift has to be registered compulsory. Unlike the will, gift is under section 17, which is compulsory registration. It comes under that. So this gift can be given either for a compensation, or for a consideration, or for a natural love and affection. Now we will see these three components. One is compensation. Sometimes you got something from another person, okay? To compensate that, you may give a gift. Another one is consideration. This is very, very clear that you will give a gift. You may take a consideration also. Another natural one, or most 90%, is natural love and affection. Gift means 90%, it is said that you give out of your love and affection. It could be to your kith and kin, or to charity, or to a trust, or to a third person. All right. Now, again, coming back to Dhoni. Dhoni is a person who has to accept. So in gift, it's very, very essential that gift, you cannot say a gift is complete till he accepts it. If there is no acceptance, there is no gift comes to an end. There are 5 elements which is very, very important in gift. They are transfer of ownership, number 1, first and foremost. There has to be a transfer of ownership. Number 2 is existing property. Unlike the will, wherein I may say that today I might have a property. I write a will today saying that all my property will go to X. So I say that which is not in existence today. Today, in 2022, when I'm writing a will, I do not have a palatial building, but I write all the property, including palatial building, which may come tomorrow or day after. So I'm writing for a non-existing property in will. Whereas in gift, you cannot give a gift which you don't have access or possession as on date. The next is transfer without consideration. Here, as I said, 90% is without consideration, but very, very rarely, there are few examples wherein they take a minor consideration to transfer the property. And the 4th one is voluntary transfer with free consent. This is very, very important. You can't coerce or influence a person to gift a property to another person. So that becomes invalid straight away. Next is acceptance of the gift, which we just now saw. So there'll be 5 elements, which is very, very important to fulfill a gift. Now, what happens if I give a gift? Now we saw in the will that it could be cancelled. Or can we do that in gift also? Yes, you can do that in the gift also when, if A is gifted a property to B, A and B together mutually should go and cancel the gift. It cannot be done vice versa. It has, because the minute you give a gift to somebody else, the minute he accepts it, so there what happens, it comes to a conclusion. So we cannot ask for a cancellation by only one person. It should be by both the person. Then gift of future property. Now, what happens, as I said earlier, that conditional gift we give, the person does not fulfill the conditions. Can it be revoked? Yes, for sure. Because that is where we say that you have to put the condition when it has to be revoked. So, for example, A says that B should take care of him or pay X money every month. 3 months, 4 months passed that B does not pay even a single pie to A. So A writes a notice, letter to him. Look, I had given you a gift on so-and-so date. In that, so-and-so clause says that you have to pay me X money by every 5th of every month. Having said that, you're not paid for the past 3 months. If you do not pay immediately or within 15 days, I might revoke this gift. You give a notice and wait. You wait for 15 days. You see the answer. If it is not in your favor, then you take this notice and go to the concerned sub-registrar office and say that, look, I had a condition, he is not fulfilled it, so it has to be revoked. I had one more slide, and that's why I'm not able to get that slide. Now let's see what happens. Now we said that gift is compulsory registration. However, there is a myth saying that Muslim law does not say, because we call it as hiba, it does not call for registration. What it says is any will, the consideration or the property is more than ₹100, it is compulsory registration. But a lot of people think that no, hiba is not necessary for registration. But I just want to inform that it is to be registered, because the section 17 says, is for Indian Registration Act says that everything is registrable. Okay. Only thing is that they do have will. They call it as wasiyat. So that it could be oral also. Will, not the gift. Okay. Any questions, please?
Yes, sir, I have a question.
Sir, I don't understand, sir.
Yeah. Tell me. Yavdu understand agila?
So that grammar part.
Yavdu? Which one? Manju?
Manju.
Sir, can you repeat it again? Summary.
Summary of?
Sir, your voice is not audible, sir.
Hello. Am I audible to others?
Yeah, yes, you are. Basically,
Okay.
saying last 2-3 sentences you summarized, right, about the Muslim laws and personal laws and things like that. The last summary, he's asking for that summary of it.
Okay. Now, what happens is a lot of people think that a gift, no need to register if you are a Muslim. The law is very, very clear that if the property is more than ₹100, it has to be registered under section 17. That's what I said. And number 2 is that sometimes the will could be oral will, not the gift. I just want to distinguish between oral gift and the will, because Muslim law is little different than the Hindu law. So there we call it as wasiyat, will, which is oral also. That is what I said in the earlier session, which you want me to repeat it. Yes. Any other questions, please? Hello.
Okay, Bantu.
Yeah.
So there are a few questions on the chat window. Shall I read it for you?
Please, Mr. Muthu.
Yeah. It says, how long the will is valid? That is from Raj.
Okay. Can I maybe this we can stop the sharing so that easier I can see it. Now much better. Perfect. Yes.
Right. He says, how long is the will valid and how many times can it be changed? That I think you already answered.
Correct.
Right. So someone asked, kindly explain CAA and NRC in terms of properties and things like that. CAA and NRC. If this is something to be skipped, we can skip and move. It
is not relevant actually at this part of this juncture. Right. Is not relevant actually.
Right. So the next question is, can a will or a gift be kept confidential till the death or till certain period of willful time?
Yes, will can be kept in confidential, but not the gift. As I said earlier, gift is, you know for sure he or she is going to enjoy the property before your eyes. Whereas will, for sure, it is confidential. Okay, you will open it only when when a person is no more, you go to sub-registrar office if it is registered. All right. Only the kith and kin can get a copy of the will from the sub-registrar office, or that is, which is kept very confidential. Next, I see, can a gift be revoked? Yes, we talked about it. Both the parties together can revoke the gift. That is one. Number two is where there is a conditional will, and if you have not fulfilled the condition, then it could be revoked. I see, what is NKN? I don't know. Any other questions you have? Now, it's always good to have interactions because let me tell you, law is very, very, subjective. If it's good that you ask me question, I can share my knowledge. It's much, much better. It could be silly. Do not worry about it. Ask questions. Your question could answer many people's, questions which they did not want to ask, but your question could be answer for many people who are present here. Yes, that we answered already. Can a will be a gift or kept confidential, which we answered already.
Is Pavitra around? I have one more question. Can I?
Please go ahead.
Right. So now, since that you mentioned gift is better than will.
Yeah.
Right? So let's assume wife has made a will.
Yeah.
Wife and husband jointly made a will.
Yeah.
In the beginning, and wife is no more now.
Okay.
And fortunately or unfortunately, now they realize it is better that I make a gift, because tomorrow my daughter should not come and trouble my son.
Got it.
Because they were good in relationship before,
Very
but
true.
unfortunately now they are not in good terms.
In
that scenario, can he make it a gift now, because it is one party who was there? Before it was a joint party decision. Now it is one party. Now what is the best suggestions that you have for this?
Correct. Now, as I said earlier, the minute he loses his wife, the ownership goes to the legal heirs. 90% of the time, if the other kids are too young, it goes to the husband. All right. So he becomes the owner of it. Then he can give a gift. No problems. It's very, very clear.
But they are elder. They are matured. They are
no problem. Still, also can gift it to. If it is major, what happens is they have to give a no objection certificate to get a kata in the husband's name alone. Otherwise, what happens? The wife's share will be divided by all the legal heads. I don't know how many kids they have, 1 or 2 or 3. It gets into so many pieces. Unless until they give NOC saying that I'm okay to have together with my father, you will not get a kata, or the property share will not go to the particular person.
Right. Got it. Understood. So thanks for that.
I have a question over here, sir.
Please, sir.
Can a donee be a private limited company, or a donor? A donee, the person who takes a loan, can he be a private limited company?
Yes, sir. It could be not a problem at all.
It could be a company also.
Yeah. Because, for example, I have a property. I have a nice laptop. I see some company who's doing a good job. Okay, who are helping a lot of people. I may say, okay, I want to give this property to this company who's doing a good job. But again, company who you represent, that becomes the question. Company, because it's represented by one particular officer. So you will say, yes, it goes to the company for sure, but who's executed? You'll have to mention it, because people may come and go, but company will be staying there forever.
Correct.
Okay. So it goes to the company, no problem. It is possible.
What about a partnership firm?
Now, any legal person, so all their person we know, and it could be a company, any entity for that matter.
Okay.
It could be a donor, not a problem.
Okay.
But
Thank you.
how they're going to take it, that's a challenge. Tomorrow I get it. Donor gave it with so much happiness, but Dhoni should not get into problems that, I want this, I want that. That you have to be careful on that.
Very true. And in courts, I'll be seeing a lot of cases which will be pending for 20 years, 30 years. May I know the reason, major reason for it, why it's not been resolved?
Correct. There are a few reasons, I would say, not one or two. One is that maybe lack of time to the judiciary right now, which is now getting much better, I would say, because earlier we had a lot of challenges, but now we have more court halls, more judges. It's getting faster, number one. Number two is the participant. If you are a party to the case, sometimes, let me tell you, we always blame the judiciary. Sometimes even we don't do that, what is required for the particular stage. See, if it is posted for evidence, if you don't come, what the court will do? You don't come for whatever reason. You come, your judge will not come. It's advocate will not come. Advocate will not come. You will come. So if both of you come, document is missing because it has to be marked. So there are so many, small things which takes a long time. So that's what I say. It's not only one reason. There are many reasons. And sometimes what happens? You are there, your lawyer is there, but other side person is not there.
So all the five parties has to be available.
Yeah, to make it fast. Sometimes 5 parties are there, but document is not there. It's not available because it is, evidence is basically the document you have to prove. You have to apply and get it, certified copies, but that is not available. So there are so many ifs and buts. Touch wood, things are much better than what I started off my profession, and today we see a sea change. I'm sure we are going to the better days.
I believe with the help of technology mainly.
Yes. Not only technology, even the restrictions earlier, with due respect, earlier we could get time very easily. But today you don't get time unless until you prove why you want an adjournment. It has to be a genuine reason. Otherwise, courts try not to give time unnecessarily.
Thank you, sir.
Yeah.
I have one more question. I know
please.
I'm loading you with questions.
No problem. No, as long as people are benefited, it's okay. Please go ahead.
Right. Who pay the taxes as soon as it is gifted? The donor, Dhoni, or yes. Let's assume a couple of months ago it was gifted to me. Okay, not couple of months. Let's assume I had an interest to person A had an interest to give it to person B. Person written the gift, accepted psychologically or on a conversation, but not told, but written, backdated. Matlab 1 year ago, but not registered.
Yeah.
Okay. Suddenly his health is not good, and realize that and go for a registration. Okay. So 1 year he did not pay the dues at all. This is not the case, but this is an idea that is coming up.
Got it. Please go ahead.
So in such scenario, who pays the dues? Matlab, from when is it to be paid?
Correct.
I know it's a silly question, but
no, please. I told you already, nothing is silly in this world.
Right.
Okay. You have to ask whatever you have in your mind.
I'm just thinking aloud. So
Please. Good. Now, I'm sure many people would have want to get an answer for that, but now they'll get it because of you. That's why I say it's good to ask questions.
Right.
Very good question. I do not know whether I told you today or not. When you go for registration, there are a few things we have to carry. Okay. Those things are, first and foremost, a gift deed, which says from A to B. Number 2, you'll take a latest Kata certificate and extract, which says that who's the owner as on date. Okay. Number 3 is you carry latest tax paid receipt. There, your answer comes there. So today I want to gift it. until date, I should have paid tax. Otherwise, I can't do a registration. Okay.
So which means the person in the deathbed, son will go and pay on behalf of his father. For the last 1 year, he has been hiding. Okay.
We're talking about only gift, no, Muthu?
Gift, yes.
Yeah.
But he didn't say it. He has written it, but not told and not signed it, not implemented, but already written a draft and kept it 1 year ago.
No, when I go for registration, see any document, no, for example, if you write a agreement or a gift deed today, put a signature with a date. That's valid only for 3 months.
Okay. All right. Got it.
4th month, you can't take with the same document.
Okay. Got it. Got it.
You have to change the date.
Got
So
it.
when you go with the date, then as a sub-registrar, I ask, where is the taxpayer receipt? You'll give it to me. So on that day, whoever is giving it, you would have already paid it. Coming to your very good question is, the property tax paid either yearly or off yearly.
Correct.
Okay. Now, since we are sitting in April, you can pay only for the first 6 months. That you have a choice. The later 6 months can be paid by the donee.
Successor.
You have a choice. Or if you're, maybe it's going to be your own person, kith and kin, you may pay the entire tax also.
Correct.
Choice is yours.
Got it. Got it.
Anybody else? I see many people, but anyway, only few are on the video. For sure, others are listening to me.
Any other questions?
Go ahead.
Sir, good evening, sir.
Please, sir, tell me, sir.
Sir, I have a question.
Please.
Is there any, section saying that if once the gift is given, according to that section or this section, can it be taken back?
No, section 126 deals with revocation. Okay. And that says where there's a condition, I told you, that which we covered already.
Okay.
If the condition is not fulfilled, you can go for a cancellation.
Okay. That gift can be taken it back now, sir. Revoking.
Yeah, because of the failure of the condition. You have to prove it.
Okay.
Not otherwise.
Okay. Thank you, sir.
Yeah.
If no questions, I can ask one more question. Because people in my companies keep asking me, employees are really dull. I ask them what happened, this happened, my property gone like this, so I want to leave. So I keep hearing it, right? So I keep coming out with questions.
Please go ahead, sir.
So basically, if one of them gifted me a property, but that is under liabilities. Okay. So, and unfortunately, the person who is given is no more now. The liability is, let's assume a 10 lakh rupees liability, and the property value is also 10 lakh rupees. Now, just in case. Now, who is responsible for that liabilities? Now that the property is gifted to me, now, am I responsible for the 10 lakhs liabilities?
No, sir. I don't know whether, let's go back to the 5 essentials of a gift. What I said is existing property. So you should have an existing property. So you're saying there's a liability on that.
Correct.
So it becomes his duty to clear the liability and give me a gift.
He didn't. He thought
then he cannot, it's not a valid gift.
Oh.
So I can't give a gift with the negative things and give it off to you.
Okay. So which means if in case even if he gives, I'll have to clear the liability to the bank.
Exactly. No, you will not. We don't entertain that. That is why I'm saying, if presume that in your case, A has got a property which is mortgaged to X bank, he is not paid the EMI. You can't get a gift of that property because bank will not allow you to gift it.
Will,
yes.
Okay. Now who is liable for the liability? Who's liable for that 5 lakhs to the bank?
Will, yes, you are liable.
I am liable.
Yeah. Because if you got the property, So
I'm not the legal heir. I'm not the legal heir, but unfortunately, nobody is got. Nobody is an individual. Since that, I have taken care of him for a couple of months. He was in Bangalore, so I took care of him. So, with out of love, he wanted to give a will. So, in such scenario, his liability, I can pay that 5 lakhs and I still get it back.
Maybe since it's maybe little, it's not the real case. What happens is 99% we never get a deficit through will. It's always the benefit which we get of it. Very rarely I've seen that there is a baggage which comes with the will.
We had one such employee asking, and he had to. So that's why I asked you.
Correct. I have not seen so far in practically.
Right. They were actually. They lived like a family, but they were not family. So they didn't have son and they didn't have children. So they wanted to gift it back to them. But unfortunately, they had some liabilities.
Correct. So but that's what again we have to be very clear with the word gift or will.
That I also don't know.
Yeah, we have to, because it's people misuse this, but it is not. It's got a two distinction things. Correct. Yes, Mr. Kiran, please go ahead. Kiran raised his hand. Please go ahead. Okay, Kiran, I think is showing his hand, but I don't know. No, he's not responding.
Maybe technical glitches sometime.
True.
Pavitra, are you there?
Yes, I'm here.
Yeah. Please.
Okay. Request the participant to kindly fill the feedback form provided in the chat box. So you are having 3 minutes to fill that form so that we can share your certificate through email.
That was really, if I can just quickly say a few things. That was really wonderful. I mean, you've been very patient in answering all the questions with all the smile on your face to help us understand. I mean, I know I've been really bombarding you with questions too.
Not at all.
Yeah.
It's my duty.
You've done a great job. I really got the answers for all my questions. You did really, really well. Thank you so much, for being so nice and kind and explaining us so peacefully and patiently. Thank you, sir.
Thank you so much, sir.
So, I have one question.
Please.
It's not a question. Can you share one of your experience where you felt that it was a different kind of case which you handled?
No, to be frank, there is one case where I handled where the will was involved. I don't know whether you got the point where he became blind, Allah. It's a fact. He was apparently a very renowned person. I can't name a person who's got a lot of awards and all. And when he was almost 70s, he loses his sight. Okay. Then he writes a will and gives it to gifts. He says in the will that it will go to the granddaughter. And he's no more then. And one good thing what he did is, I said we need 2 witnesses, definitely. He got 4 witnesses. Okay, what he does is he asks the people who may create a problem to come and be a witness. That is this, because I said he's a different person with the society. He's got a good name. He also anticipated that this person may create a problem tomorrow to my granddaughter. He asked them to put a witness. They also put a witness. Even then, they file a case saying that he is a blind person. He does not know the content of the will. So the gift, the will, what has been executed is not correct. And which we said, no, there's a clause specifically saying that it was read out to me. I understood it. That's when I put my thumb impression. If this clause are there, you cannot say the same stand. Okay. And which we won actually. Having said that, that's why I said no, India is different. Other person has gone to High Court. It is pending there for almost for the last 4 years it's pending. Maybe one fine day it will come. Then I have to take the case forward from there. So it is very, people do so much caution and care. Even then, you end up going to litigation. Today, neither the granddaughter nor the person is enjoying the property. It is just, it's one of the prime land. So that is why I always advise, please prepare a will, give it off so that he or she gets it today and they enjoy it. Not like this, you go to heaven or wherever you are, but the kids, they end up in litigation. They go almost every week or every month to the court, spend the valuable time. And I'm sure they may curse this person also for making them to run around to the court. So that is why I always tell you, think twice. It is nothing wrong in giving a will, but if you're clear, give a gift so that it's very, very clean. And they also bless you also. A daughter or a son saying, oh my God, see, my father did it to me, which may not happen in the will.
Very important topic for these days, you get to hear a lot of things, challenges like this. Very, very important topic, actually. I thoroughly enjoyed it. Thank you.
Especially during these tough times.
Absolutely.
We don't know who's going to be there tomorrow.
True. We didn't anticipate Punit Rajkumar will, at such a young age, so we don't know. It's good to have such knowledges and spreading across such knowledge. Good. Thank you.
Thank you. Pavitra, you're there?
Thank you so much, sir. Yes, sir, I am there.
Yes.
Now I request Professor Gopal HR, Principal of Hoysala Degree College of College Nelmangla, to give the vote of thanks.
Thank you, ma'am. So far, we have listened all the details regarding the pros and cons of will and gifts. These days, it is very important for each and every citizen of India to know the value of will and the gift. So today you have given us, you are enlightened us regarding this particular, the very good topic, sir. Thank you so much, sir.
Thank you, sir.
Thank you so much, sir. Now I request all of you to stand up for national anthem.
Okay, we need to stand up for national anthem, right?
Yes.
Yes.
I thank Speaker Mr. M. Jagadish for wonderful this session about will and gift. And I thank management, teaching and non-teaching student or non-teaching student of Hoysala Degree College for participating. And I thank all the participants for participating in this session, making this session wonderful. Thank you so much all.
One second. I think there some feedbacks which has to be read. Awesome session. Thank you, sir. Very excellent session. Thank you for the valuable information from Bhamini.
Thank you for giving me an opportunity to share my knowledge, sir. Thank you very much. I thoroughly enjoyed with all of you.
And from Disciples India side, was a wonderful session, sir. Thanks for the inputs. It was. And before has come up, if you're okay,
So your voice is breaking, sir.
We could not hear anything, Shivu.
Yeah.
Can you repeat that?
yes. Can you throw some lights on Mrs. Jayalalitha's case?
Oh, he's asking you to throw some light on Jayalalitha's case.
There's a question which
Good.
But that's the, I don't know whether you know or not.
question.
It was 600-page judgment. So which one you want to know? I don't know.
It was a question from audience, participants.
Correct.
I think you can summarize it.
No, that's what she had got several the case went into a different tangent. So I do not know the person what he or she wants to know about it. So unless until we are very clear, we cannot talk about it because we are all on public domain, not right on us to speak unless until we have clarity on what is that he or she wants and why. Maybe for particular information, maybe we can take it offline, but not on the public domain. It's not correct.
Yes, the participant in further questions can be asked directly with sir
Yes.
after the session is over.
Yeah. For sure, I will support whatever I have knowledge.
Thank you, sir. Thanks
Pleasure,
for a
sir.
wonderful time. Hope
Thank you,
everyone
thank
has
you.
taken up wonderful inputs, which was given on will and gifts. So thanks a lot for your time.
Right. I kept it
Pavitra,
very common so that I do not want to look like too much jargon, sections and all, which for sure it will not get into your mind. You need to understand the concept. It's easier than giving you with the sections and all those things. Then you will think, oh my God, another class here. I do not want.
Thank you, Mr. Jagdish, for enlightening us with the knowledge that you have, and thank you. We had a good session and good time. Thank you.
Thank you, sir.
Thank you so much, sir, for your wonderful inputs.
Thank you, madam. Thank you, madam.
Thank you.
And before we end, can majority of you can switch on your
Camera.
video so that we can take up a photo.
Yeah, right.
Yes.
Right.
Then switch on your camera. But you can take a picture.
So you should stop sharing screen, then only it comes as full screen. Otherwise, yeah, right. Maybe let me, if I can take a gallery view. No, I think I can. Okay, so if all have switched on the cameras, then we can go with a count of 3. Okay, 3, 2, 1. One more. Okay.
Request everyone to switch on your video.
Yeah. I think slowly they are switching on. Or they
So the photo makes all the the people to come on live.
Right.
So I should have told this advance only. We will take a picture. Please come on video.
Yeah. My request all the other folks also to come on the picture. Maybe you switch on the video so that we can take a good group picture. Yes. Yes. Opening one by one. We have a few more. Bhamini, Chandu, Rakshita, Monali, Monica, Aishwarya, all of you can open on your cameras, all of you. Shweta, everyone. I can't read out the lot of names around. Right, almost done. Yeah, 3-4 more folks. I will click. Meanwhile, they open, I'll click some more. Yeah, all right. Thank you. Yeah, more opening.
Thank you.
Thank you, folks. Yeah, I clicked few pictures, Shivu. Yes, Shivu.
Yes, thank you, Muthu.
Yeah,
You can share the pictures.
I will do.
Yes.
Thank-
Over to
thank-
you, Mitra.
Thank you, all of you.
Good day,
Thank
Mr.
you all.
Jagdish. Thank you all.
All right. Bye-bye.
Bye.
Have a good day.
All of you, take care. Have a good night.